IP is going to be the key driver in all those three areas in the next 20 years. And most of us sitting here are people who are going to be making a difference in our own organizations, in our own areas, in our own firms, companies, and discussion forums. So let's understand a few statistics before we go forward. The topic for today is 1995 onwards, how India is, and the TRIPS and 2015, how have we kind of progressed? Let me give you a few numbers. In the year 1995, the total number of reported cases. See, I don't have the statistics about actual cases which were filed, but we did conduct a study about reported cases which are reported in Manupatra, PTCs, etc., as you all know, about on the field of intellectual property. In 1995, there were a total of 47 reported cases in IP. 29 went in favor of the IP owner. In the year 2000, there were a total of 69 reported cases, and 45 went in favor of the IP owner. In the year 2011, there were a total of 204 IP cases which were reported, and 131 cases went in favor of the IP owner. I've done a mapping, and I'll pass these statistics across to Akriti. She can actually circulate them. There are charts which have been prepared. The total number of cases reported from the year 1995 till 2014, that's a period of almost 20 years, 2,157 cases, and in favor of IP owners, 1,433. That's a total number of 66.43% of IP cases being decided in favor of IP owners. And if you look at further statistics, you will realize that 80% of IP litigation in the last 20 years does not involve a foreign company. Reported cases, they don't involve a foreign company. This is not surprising. In fact, as practicing lawyers who are active on a daily basis, though the headlines are made by the foreign company cases, the core and the nucleus of IP cases is the domestic IP cases and the domestic industry. I'm talking of both sides being domestic. So 80% of IP litigation is driven by Indian companies in India, which is not surprising at all. But it is surprising considering the way the media portrays Indian IP as being pro-Indian and anti-IP. If you look at statistics on that, you will be surprised that 60 out of the 2,100 cases which I just mentioned, 600 cases involve foreign companies on one side or the other. And out of the 600 cases which involve foreign companies on one side or the other, 67% of cases have been decided in favor of the foreign company. So these are the hard facts. As they say, lies, damn lies, and statistics. I would call this truth, real truth, and statistics. Let's look at this in the correct perspective. Let's portray Indian IP the way it needs to be portrayed with the actual facts, rather than going by perceptions. Now let's come to the perceptions in the USTR report. The USTR report of 2013 says that India is on the priority watch list, and there will be an out-of-cycle review this year by the US about the status of Indian IP. In my own view, the report does kind of fairly give the pros and cons of the Indian IP system. However, there are some statistics that go completely unnoticed, which we should all bring to the notice and bring to the fore. The first area where the USTR report speaks positively about India are the copyright amendments, which were carried out in the year 2012 and notified in the year 2013. And the report speaks positively about that. While speaking positively about the copyright amendments, since The Copyright Board is yet to be kind of established. The chairman has not yet been appointed, though the infrastructure has already been developed for it in Delhi. The report rightly says that there is a problem insofar as online and video piracy is concerned and camcording piracy is concerned. However, when I do accept that this is a huge con insofar as India, a big criticism about India, I would think insofar as online and video piracy is concerned, this criticism applies to almost every country in the world. There is no country in the world where online and video piracy is not taking place. For example, when I travel to the US, I see that almost every Indian channel, television channel, you can access through the broadband or the internet protocol without paying any money. The entire Indian broadcasting industry hardly earns anything from the US, and that's a fact. So yes, we need to take steps to curb online and video piracy, and I would think that there are a lot of measures which can be kind of promulgated in India to stop it. The judges and the judiciary has done a lot. If you see the recent trends in litigation in copyrights, you'll see that in the recent FIFA tournament which was held, the Delhi High Court passed a John Doe order, almost blocking every website which had pirated content of FIFA. We need to do a lot further in online and video piracy. Let's look at patents. In patents, the pros have been listed by the USTR report, and that is the examiners hiring, which the patent office has done on an overdrive. There is an expectation that there would be at least in the next 2 to 3 years, 500 new examiners who will be hired by the patent office. And in this context, I would like Mr. Anand to expand on what has happened in the Neetu Denko case in the Delhi High Court, which he mentioned about in the plenary session when he takes over the floor. Because there is a lot of development in this area, and rightly so. There is a lot to be done and which needs to be done, but the report does highlight the 500 new examiners which is being recruited. And the report also mentions the high-level committee set up by the Delhi High Court in the Neetu Denko matter as being a positive step to increase patent examination targets. For example, we take at least 4 to 5 years to give the first examination report after the request for examination is filed. That period needs to be reduced to a great extent.